What's up, Gray Moon? Oh, what's up, everybody? All right, I didn't want to do this a whole lot. Like, there's there's a reason why we haven't done a lot of Chris and Kirk's videos. In all honesty, I just think they are boring as shit. But unfortunately, with like what we've been talking about pretty hardcore this entire week, and I imagine will be a subject we go back to over the months to come as like the legal process starts and everything like that. Uh, there's this live stream with Chris Hallett and Neely, which I want to give a shout out to Glow for finding that and putting that back on their channel. So this video though, like, I don't even blame any of you if nobody really sits through this one, because it's just gonna be fucking boring. Like I said, their videos, it's just very drab explanation of sovereign beliefs. But for anybody like really interested in this murder of Chris Hallett thing, this whole sovereign group, this is an example of the sort of sovereign laws that they were putting into Neely Blanchard's head before she actually ended up, or is accused of murdering Chris Hallett last Sunday and being indicted for the kidnapping that she did of her children in March of this year. She was just indicted in Kentucky on Tuesday before the actual shooting. So a lot of it looks like Neely's got a criminal history, a long criminal history. Chris Hallett has a history of losing court cases, basically. Chris Hallett is not a patriot. This is not the Great Awakening. America is not waking up from this. Chris Hallett was a fraud that taught sovereign law and taught it to the wrong person. So yeah, Chris, if you look into his court records, I mean, as recently as January, a federal judge told him that he was not going to entertain his fantasy that he was acting on behest of the president, because E-Clause, Chris Hallett, and Kirk Pendergrass, they claimed that they were doing audits for the government and all of this other crazy bullshit. Neely, like, I haven't watched this video all the way through, but this video, I think, explains a lot more of like what it kind of gives a first-hand view of some of the shit that they were pumping in her head and what could have led up to her actually doing this shooting. So, like I said, I can't stand their videos. I think they're super, super boring. But due to the circumstances, we are going to watch this video. And again, I'm not mad if any of you guys bail on me on this one. It's 50 minutes, and I think we're going to try, and I'll probably do some interruptions like normal, but for the most part, I just want to try and get through this fucking thing. Your fear is showing, Bumblebee Tuna. Okay, Nicholas. Yes, people's fear is showing because they realize that your heroes can't win a court case, so you're totally correct. Okay, here we go. Fuck. Oh, here we go. Okay. Oh, and this is June 30th, by the way. So at this point, Neely's already been arrested for kidnapping her children from her mother's custody. Which, by the way, the Secret Service actually got involved with that arrest, which that's not normal for the Secret Service to assist in a Amber Alert. So That was likely because these groups are starting to cause enough problems that they're getting the federal attention, which isn't really surprising. So here we go. Let's watch Chris Hallett with Neely, and we'll see some of the nonsensical legal theories that he was pumping into her head.
Setting up your meeting.
Here, there's no comments or anything, so we'll go ahead and full screen it.
Okay, I think we are live. So good afternoon, everybody. I realize this is a little early. We're not usually not due to start on our normal venue until later this afternoon. This is actually...
I have not, Robert, I haven't heard anything about Neely staying at Kent Hobbins. I'm actually not sure of her path. That's actually an interesting thing. I haven't even really thought about that, of where she went before the shooting and her whole little path up to there. I haven't heard that. But that's kind of one of those areas that I was kind of waiting for law enforcement, just like the clarification of whose gun it was. I don't want to say whose gun it was, or claim to know 100%. That's some of the stuff that I kind of want to wait for until Marion County gives us another update and gets a chance to talk to Neely and all that.
Going to be an official broadcast under the jurisdiction of this office, under Title 28 U.S.C. 1443, under Civil Rights Removal Statute, which clearly states any of the following civil actions or criminal prosecutions commenced in a state court may be removed by the defendant to the District Court of the United States for the district and division embracing the place wherein it is pending.
And just so like we're clear, this is like documents that Hallett was putting together for Neely's case and shit. They like go through stuff that he was actually doing in her case. So this is like legit some of the stuff that added or like led up to the actual shooting.
That would be here in Florida. Florida was the crime scene, right? And this is against any person who is denied or cannot enforce in the courts of such state a right under any law providing for the equal civil rights of citizens of the United States or of all persons within the jurisdiction thereof. And number 2, for any act under color of authority derived from any law providing for equal rights, or for refusing to do any act on the ground that it would be inconsistent with such law. Here's the cases and the citations as mandated by the federal judge. So now that we've established this office's status, standing, and lawful jurisdiction, let's dive into it. Basically what just happened, and I'm going to pull up the original establishment of this office's lawful jurisdiction pursuant to this document.
Oh, God.
This office was created by the consent of Congress. It is what it is in this case. So, the preface for the creation of this office is going to be as follows. This following report is presented for review in good faith as a friend of the court.
By the way, every court document that I've seen related to Chris Hallett versus Ohio, he lost. He lost his appeals. He lost everything in that case. He did not win that case, if that's the same one he's referring to. I don't know if there's another one. I still need to dig up some more shit on him, but if you go look, I mean, you can find the case files yourself. You can hop on Google and look for Chris Hallett versus Ohio, and you'll see that he lost everything with that. He did not win in court. I believe that was the one that was over his child support, and he was asking, or he was demanding that the court give him $33 million for the damages he ensued from not paying his child support and being looked at as a deadbeat dad and blah, 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 whatever the fuck else he claimed. So I think right now he's reading off of things that have already lost in court in the past.
Under license number 443-079.
Melissa, yeah, you can feel free to shoot it over. He shows, but he, like, from skipping through this video, he shows like shit he was entering for her. At least I believe. That was the gist that I got from skipping through it.
As a fiduciary practitioner consisting of 9,301 words on 39 pages, not including dicta and appendix sources, my license holds and is subject to the high standards consistent with other fiduciary practices of care, sense of fair play, and equal protections under the law. My work is presented to this court in efforts to assist the case presentations in working with the plaintiffs in these matters toward protecting the integrity of these proceedings. The court.
Melissa, my Meko profile is it's like I can still message and shit. I'm just in regular Facebook jail, so you can even just send it to my regular Meko profile. Nicholas R. Griffith, losing in kangaroo injustice system doesn't mean jack squat. This is exactly what is being exposed. Okay. Isn't the whole idea, though, that Chris Hallett and Kirk Pendergrass can win cases for you? If they lose their cases, isn't what they're claiming a lie then? Like you're... Oh my God, you people give me headaches. Okay, so are you arguing that losing in court shows that they know what they're talking about, Nicholas? I'll give you a second to think about that before you type words again. I just want to make sure that I'm clear on your argument.
That means Lady Justice. And these plaintiffs in congruence, a task not undertaken lightly, as the very course of multiple lives will be forever altered. Therefore, the utmost care must remain the standards of practice. Right? This is those high fiduciary standards we talk about, to ensure the continuation and protection of the Constitution of the United States be interpreted as the 56 men who constructed it intended, basically. So,
oh shit, we got a few you turds coming over tonight, huh? A couple of you are brave enough to comment already. Which, please, my sovereign kiddos, feel free to comment. You don't have to wait until I'm done with the live. I see that's what most of you do. You're just saying they never stood a chance if they memorized the entire Black's Law dictionary. Okay, but the problem is you're saying, you also said Chris Hallett was a hero and a patriot. Chris Hallett claimed he could win in court and he would lose in court. So, are you saying that they knew they didn't stand a chance and they were lying to their clients? Like explain this, because they lost in court, but they claimed that they could win.
What may seem so rudimentary to so many when in consideration of basic equal protections and basic due process, that would be that basic Magna Carta due process, as related to this practice, are luxuries that has never been afforded. The fact it has become arrogant and hostile is a side effect of this type of exile, meaning the bar and its practitioners. It is for this reason.
Bill Scott, people lose. God, okay, maybe this stream will be more entertaining than I thought. People lose because of the sheeple won't stand up for themselves. Bill Scott, what if people lose what if these people lose because they don't understand what they're reading? I mean, like, did Chris Hallett and Kirk Pendergrass, do they have somebody explaining what they're learning and making sure that they're not just perceiving it wrong? Do you have someone that understands the law telling you yes or no if you're perceiving it wrong? Or do you just read stuff online and then feel like you got it? Bar attorneys are in violation of the Nobility Clause in the Constitution and the Foreign Agent Registration Act of 1938. Okay, Bill, why is that exactly? Can you explain and go into detail of what's being violated and why, how?
My personal choice of profession was outside of this area of service for years. That was until I received a knock on my door, which forever changed the course of my life and forced me into action for no other purpose than self-preservation in my own case. Like so many before me, I had, for the longest time, given up and decided not to care. I then remembered this quote from the Declaration of Independence, which led to my work. But when a long train of abuses and usurpations, pursuing invariably the same object.
Like, I can tell you already, just from this document, just this part right here, this is not something that you would enter into court. I mean, he's just randomly talking about things that he remembered and shit. That holds no weight in a fucking court. That really holds no weight anywhere. Who gives a shit what you randomly remembered?
Evinces a design to reduce them under absolute despotism. It is their right. It is their duty, in my case, the fiduciary duty, to throw off such government and provide new guards for their future security. Well, that is the commencement of loss prevention, right there. So, basically what happened when these foreign actors violated the Foreign Emoluments Clause, came in here and thought they were going to take over the place. Not happening. We have law against that. It's the Foreign Emoluments Clause in the original 13th Amendment, which I further outline in this report. This is the reason that this conduct has oversight, and my office does have oversight under the aforementioned jurisdiction. Therefore, in so much as lawful notifications are concerned, this is the notice to agent, notice to principal. Under Bullock, where fraud upon the court is directed to the judicial machinery of the court itself, basically is a short version. Here's the letter of the law, Article 4, Section 4. We're guaranteed a republic.
Okay. I'm sorry. I don't want this to be like a 3-hour ordeal to get through this video, so I'm going to bounce back and forth. I'll kind of try and keep an eye on you over there, Bill. And then I don't know where other homeboy that thought Chris was a patriot dipped out to. Here's another problem. The court stated fraud upon the court is fraud which is directed to the judicial machinery itself and is not fraud between parties, blah, blah, blah. So he's referencing a case there. But the problem is, what is he referencing the case to? Like, if this is where sovereign law is confusing, and you really don't even, I mean, for the most part, reading through this and just thinking logically about it, you can see where the fallacy, where the total, it's not even fallacy, it's just total bullshit. What is this directed towards? If he's referencing this case, why is he referencing it? What did the agency he's talking about, or the court, or the judge, or whoever, what did they do? There's no actual target for who he's comparing this random case to. He's just throwing in a random case file, and there's nothing, it's not connected to anything. He's just referencing it without referencing it for anything.
I don't care if you bar members like that or not. I could care less. So what just happened? What just happened here was violations under the Hobbs Act. And I'm going to specifically define what they are.
But what happened? Because, okay, before this, we haven't even talked about what happened. And then, Jesus Christ, he's mentioning Sharia law. Oh, my God. This is a fucking mess.
Under Hobbs Act, extortion and robbery, which is Title 18 of the U.S. Code, subsection 1951. Robbery, extortion by force, violence, or fear. Unlawfully taking by force, violence, or fear. fear of injury, property, extortion under color of official right, and of course affecting interstate commerce. So this is the body of law that was just violated this morning, right? This process was lawfully served, and I'm going to show you when here in just a second, right?
You can't turn that into a court. Like you guys got to be fucking kidding me. This. Oh my God. Let me see if I can get him just a little.
Remember that.
Up. This is insanity. Fake jurisdiction, and that baseless blah. I can't really make out those last words. Advantages. Then he apparently turned that into gains. Domestic violence. Profits. Court. Gains, emoluments, profits, attorneys, I don't. Guys, like if you follow this shit, like this is nonsense. God, I think this is the first time that I've like really looked at the gibberish they're fucking giving to people. Randomly negative necessary benefits flowing to. Oh my God. Okay.
That object being pursued in the design and mentioned in the fiduciary practitioner's report. Does that look familiar? I certainly hope so, because this is that Sharia law that I talk about, right? And in so much as the letter of the Constitution in the Republic is concerned, its introduction is a violation of the 9th principle of group decision making. Period. End of discussion. Which is why the Supreme Courts will have declared its enactment void, which I'm going to clarify here very shortly. Now, whether you prefer remonstrance or remonstrance or however you pronounce it, at this point, I really don't care.
If you'll notice right there, Neely Petrie-Blanchard, I think we're starting to get into her shit. And on there it is weaponized family courts. Another thing you don't want to do in anything you're filing is just put weaponized family courts. Like, holy shit, y'all. Apparently this was from May 16th, 2020.
This notice of process was received, right, by the state prosecutor on this day by my client. So this was received. This was processed. My client is also an officer of this court. Makes her protections under this company valid, like it or not. So
okay, so E-Clause is an LLC. If you're not fully familiar with what an LLC is, I suggest you Google it. I'm not going to go super into it. It's a good way to do dirty shit with money, and it's a good way to keep yourself from being sued, basically. An LLC protects, like Chris, Chris 100% has an LLC. I can guarantee to help him. Like in my opinion, I'm pretty fucking sure he has that LLC to keep himself from being sued. Like it protects the person and puts it onto the company. So my guess is knowing that he was filling people full of this bullshit is part of why he went towards an LLC. But you'll also hear just now, he said that Neely was a part of his office and had their protection. So he, at the very least, was telling Neely she was protected because she was an agent of E-Clause, that she was an agent of his fictitious legal, whatever you want to call this, and that she was protected because of it. Things like that, I guarantee, added to the end result of this shooting. This was, he filled her head full of bullshit, and then according to the witnesses that were there during the shooting, she thought that Chris was working with the government to keep her kids from her, when in reality, Chris just couldn't get her kids back because nothing that he's fucking doing here is practicing the law. So Neely, with her already being pretty obviously mentally unstable, I could see how she twisted him failing in court to thinking that he was working against her. But regardless, that came to be because he was promising her a bunch of shit that he couldn't deliver. Like there's no protection for you from the courts because you're a fucking agent of E-Clause. That is insanity.
Intimidation of either myself or my client falls under violations under the Hobbs.
And he's saying my client. He's not licensed to do anything. Like this is bad. You can't do this at all.
Hobbs Act, and I have jurisdiction for that. I have power for that. Just so everybody knows. So,
just in case he doesn't read it, be so advised of this inevitable discovery through the attached notice of filing. The documents clearly establishes reasonable doubt. Did he misspell? Yeah, reasonable doubt to the prosecution's claims in this case. It also clarifies the fact of a mutual understanding between the complainant and the defendant leading to this prosecution. God damn it, some of these words are super blurry because he was scrolling. Something of this document is clear, and let me see if I can get a little.
Under the lawful process.
Oh, never mind. His screen capture just fucking sucks. Concise proof of concealment of a material fact, page 17, section 7, numbers 1 and 3. Constitutional provisions stand on a higher plane than statutes and are mandatory. If a Congress or state legislature violates a constitutional requirement, the courts will declare its enactment void.
Right, under the rules of the Republic, page 17, section 7, numbers 1 and 3 are as follows. Constitutional provision.
You know, it's I don't even mean to join into this part, but Mark, I just saw you say E-Clause was not bulletproof, but over on YouTube, Antigon just said an LLC won't protect you from bullets, it turns out. Don't mean to laugh at that, but you know, at the same time, I've said this from the beginning, there's no sympathy for me on this shit. There's absolutely none. These guys never showed sympathy to the people they fucking scam and take advantage of, and they're not going to get any sympathy over on this channel or this page.
Stand on a higher plane than statutes and are mandatory. If Congress or state legislature violates a constitutional requirement, the courts will declare its enactment void. Hence the reason this is above Kentucky's pay grade. I've already removed this case under federal civil rights removal statute, as I clarified. Page 25, section.
Chris Hallett cannot move. He can't remove a case. Like, Jesus Christ, dude. He was telling this chick she was protected under him and that he moved her fucking case.
Section 16, where there is more than a mere technical violation of the rules of procedure, which I just provided notice of, the violation may invalidate the act, and an act will be invalidated where there is fraud or bad faith. It is reasonable to assert failure of consideration. This is actually not part of the section, but in this particular case, it is reasonable to assert failure of consideration.
That's like really serious shit, man. He's making really big false claims to these people. Like that's really serious shit if they're believing him.
As an affirmative defense in this case. And I'm going to clarify that as we go through here.
Yeah, fuck.
Of course, my client signed it, right? And it is, of course, stamped.
Stamped or the thumbprint. This is like classic fucking warning signs that you're dabbling in sovereign law. If your legal representative, for lack of better words, is telling you that you need to put a thumbprint, chances are you need to get the fuck away from that person because you're practicing sovereign laws, nonsensical laws that are not going to help your case, regardless of some people claiming that it's because it's a kangaroo court. Whatever you want to claim doesn't fucking matter. It doesn't work in court. Like that's the moral of the story.
Proper notice of process has been followed. Due process and notice thereof have been followed, right? So this is the notice of filing to Attorney General. He stamped it. It is what it is, right? This was provided to the court.
Jesus Christ.
Notice to agent.
He really did turn, oh my God, dude. He really turned that shit in for Neely.
Here it is. For the Masons motion 39 in the 116th Congress for the United States of America in the matter of weaponized family courts, that would be this report right here. Okay?
Holy shit.
So, in so much as, where the heck was I? There I am. Okay. This is the reason for this resolution in motion.
Hey, Glow, I linked your video off. That's where I got this. I'm glad that you put that up. So, props to you on that. That was well done.
To expunge. Okay? So, as this case involves multiple states' violations of the Commerce Clause of the United States Constitution, remember, Florida was the original crime scene, hence the reason this company has jurisdiction. Every bit of this is verifiable. Hence the reason the Attorney General stamped it.
No, that's not why. You can file like anything. You can. We've talked about this before. Like I could file a lawsuit against anybody on my chat right now. Doesn't mean it's going to go anywhere. And that's what these guys do. That's what sovereigns will bank on, civil suits and shit like that a lot of the time, and even like suits against different government agencies, shit like that, because they can file it, but they don't talk about the fact that it was thrown out at the end of the day. They just show that it's filed, and people, like, it doesn't mean anything. That just means they fucking received it. They didn't win anything. They didn't, like, nothing happens from that. I can go out and sue McDonald's right now, and I can show you guys that I filed it. It means nothing because McDonald's attorneys are going to rip it apart and fucking throw it out days later. But if I don't tell you about that part and I'm just like, look at this, I'm about to take them down,
This motion to expunge comes before the...
Which reminds you, I believe this is over the kidnapping and everything, since it was in June and she got the kidnapping in March. Neely was indicted in Kentucky the Tuesday before shooting Chris. Like, she shot him on Sunday. She was indicted on Tuesday. This didn't work. Everything that he filed back in June or May, whenever was that, May 2020, it didn't work. She's still indicted. The charges weren't dropped. She was not a free woman. These are the documents that literally failed in Neely's case. She was still indicted. This didn't work. Nothing that Chris Hallett entered in Neely's case worked to have the charges dropped at all.
Body in due course of doing business as the subject of this matter is certainly frivolous in nature due to Sharia law is not recognized in this republic.
Before the murder, the Tuesday before the murder, she was indicted for the kidnapping that happened in March, where she kidnapped her children from her mother's custody, because they've always been in her mother's custody basically their whole lives. And that's when the Secret Service got involved, which again is odd because of the fact that the Secret Service normally doesn't get involved in an Amber Alert.
It is recognized as fraud. Those emoluments do not exist here. Period. Swift expungement of this matter is also clearly justified and appropriate. It also will open doors for potential failure or for potential future business relations between this company and your state in the future as an ally in fighting future emoluments violations under the Foreign Emoluments Clause. Right? You need a watchdog up there. I volunteer.
For donations, he volunteered.
My client volunteers as well. So there's your motion to expunge, right? And resolution. That's how we do business in a republic. It is what it is.
It is what it is. Neely was still indicted. She'll still face those charges because those documents did nothing. Like, she's still going to face that case too, on top of this new murder case. Like, this shit is so fucking frustrating.
So, notice of process to the Kentucky State Legislature. Basically the same document, right? And this is the remonstrance, however you prefer it.
Jesus Christ.
My client, and, acting as an agent of this office versus Kentucky et al.
He entered a fucking remonstrance on her behalf. Of course
Right?
he did.
I am the CEO of this company, and she is my corporate officer. She's an officer in training, teaching her how to do this. So, excuse me, the Office of Loss Prevention, there's my corporate identification, my fiduciary numbers, this is all verifiable, and of course my notary credentials as a lawfully created office under the state of Florida.
All this meant was he was an LLC company. He had no government authority. They were not hired by the government to do government audits. Again, in January, a federal judge said, I'm not going to entertain your fantasy that you're acting behest of the president. That was just this last January that they said that about Chris Hallett's filings. A federal judge literally told him, you're not working for the president. You're not here on behest of the president. I'm not playing with your fantasy, and they dismissed his filings.
It is what it is. In other words, to know a thing and to be bound to know it are regarded in law as equivalent. It's a maxim of law. Period. Know it, learn it, understand it, live it, breathe it.
Jesus Christ.
So,
don't do any of that.
In so much as the preface of this case, following grievances expressed within the rights and privileges of this plaintiff in her personal capacity, citing emoluments violations under United States versus Throckmorton from 1878 in her personal capacity, and Hale versus St.
I do want to point out, in all of this nonsense, he still has not claimed who is doing any of these violations or how they did it. Normally, okay, and I actually read a chunk of John Gentry, who was one of their little partners for a minute until he started blowing them or some shit like that. Some weird shit went down between them, and so I read a part of John Gentry's remonstrance. And what he was doing was trying to get rid of the Tennessee bar, I believe it was, and it was the same sort of deal. He just started talking about things that happened in Florida and stuff, which has no relevance. If you're bringing a complaint against Tennessee areas, you need to actually name Tennessee agencies and shit. You can't just randomly be over in Florida, this stuff happened, and so that's why your agency's in trouble. So that's one thing right here where it's very easy to debunk his legal claims, what office is he talking about, and what evidence has he provided that they did any violation at all? He's just naming random case law and random violations without putting it to any specific event that happened in Kentucky. He's not explaining where the violation is on any level.
Go in a professional capacity or official capacity, and all applicable federal law, Kentucky, Georgia, South Carolina, and Florida state law is needed. Kentucky, Georgia, South Carolina, and Florida state statutes of limitations as needed, and sections outlined throughout.
Yes, that's why Neely had the E-Clause license plate, because Chris had her believing she was an agent of E-Clause.
This document. Predicating this grievance pursuant to the following due process and judicial civil rules of procedure, because the only evidentiary standards I'm aware of are preponderance of the evidence under civil law and beyond reasonable doubt under federal law. Well, we're here to provide reasonable doubt. So if we can provide reasonable doubt, there is no preponderance of evidence. End of discussion.
That's not
Under federal rule of civil procedure 12H1B2, we are wishing to preserve certain defenses as listed above: failure of consideration, contributory negligence, release of my client, my corporate officer, and all of her property, injury by fellow servant, and of course, statute of frauds. So those are the defenses we will be proceeding under. First Amendment. Congress shall make no law respecting an establishment of religion.
What?
That seems pretty clear to me. Don't need any title, don't need any code, don't need any statute, rule, or regulation for that. That seems pretty clear, right? No, nothing vague there, is there? Right? So, as I just outlined, here's the petition, the section under Jefferson's, and resolution, right, under Jefferson's. There it is. So,
okay, there it is.
There's the Hobbs Act, the property as defined. The term property includes money and other tangible and intangible things of value. That would be my client's rights, that basic Magna Carta due process, which was just denied.
Jesus, the Magna Carta, the sovereigns
extortion
love that
under
Magna
official.
Carta.
Extortion under color of official right. Well, that you don't have the power to do. Nobody has the power to do that. Talk about the list of stuff not to do. Well, excuse me. The government alleges that the name of the actors in this case to be disclosed in oversight committed extortion under the color of official right on this date. Today is 6/3/2020. A public official or employee commits extortion under the color of official right if he or she uses the power and authority of his or her office in order to obtain money, property, or something of value from another to which neither that public employee, official, or employee, nor the government office has an official right. Extortion under the color of official right means that a public official induced, obtained, accepted, or agreed to accept a payment to which he or she was not entitled, knowing that the payment was made in return for taking, withholding, or influencing official acts. This is exactly what happened. I bared witness to it. My client was threatened. I was threatened.
To what?
I don't respond well to threats of domestic terrorism. Not happening. Period.
It happened. She was even indicted. It happened.
So the section further goes on to say, well, that's affecting interstate commerce, so we won't mess with it. So, in so much as the state process is concerned, because the state actually stands on a higher plane, right? Remember, the Constitution is supreme law and minimum due process. Well, we want the maximum protections for my client and her property, that specifically her children. Page 17,
That-
section 7, we went through that.
And so that right there goes into, I mean, he's calling the children the property, obviously, and we already knew this. He was telling Neely that he could get her children home, which also did not happen. Not only was he indicted, he did not get the children home.
25, section 16, we went through that. Page 29, section 35, number 3, the common law of parliamentary procedure is founded upon well-established reasonable use. It does not rest upon mere custom, but upon reasonable and equitable custom. Oh, remember those maxims from the short list? Here's one of them. What is not reasonable is not law. It's in the context of the Mason's Manual. So don't tell me legal maxims are not applicable in law. They are. May be said with reference to the common law of order in deliberative bodies, as well as the common law of the land. As we said, Title 4 violates this section. Page 38, section 40.
We are 19 minutes in, and he still has not even addressed what the fuck he's actually talking about. How this should read is, before any of this, you would start with the actual incident. Like on August 17th, 2018, my client was blah, 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 and that's when the Georgia state trooper pulled my client over and did blah, blah, blah. Like, we still, he's just throwing stuff out there. That is, this is why we haven't watched their videos for shit on here. They're just annoying. They're boring. And like one of the biggest reasons, like I can't listen to the shit. It's such fucking garbage. But it's cool. We're almost halfway through. We're almost halfway through. We're almost there. We're doing it.
3, number 9. There must be no fraud, trickery, or deception resulting in injury. As in other situations, a person is liable for damage or injury intentionally or negligently caused to another. And failure of consideration is gross negligence, period. Page 62, section 73, number 1. The people are vested with sovereign authority. My client was there to exercise her sovereign authority and was run over, expressed by their representatives serving in a legislature. Thus, legislative power is absolute and unlimited, except as restraint.
Unfortunately, like I said, the thing is, and that's why I appreciate you guys sitting through this shit. Just because it's with Neely, that's why I want it on the channel on the page. And also just so we can see the bullshit that he was pumping into her head. Like, I guarantee she's already mentally unstable. She wants her kids home. She's facing serious charges, and they're pumping all this bullshit in her head. This was clear that something was going to go wrong. I mean, in a hindsight perspective, this is clear. I mean, you can't do this. He's telling a mentally unstable woman that he's going to get her kids home. He's going to protect her from her criminal charges. She's under protection from his office. You can't do this to somebody that clearly is already unstable. This was a perfect recipe of disaster that ended as a disaster.
By constitutions. In so much as lawfully created agency practice, that would be what I cannot do in my person, I cannot do through the agency of another. Period. In other words, you don't have to tell me that. Fundamentally, principally, I know that. It was on the test, by the way, which I passed. Page 294, section 443. Number 3. A legislative body can ratify only such actions of its officers, committees, or delegates as it had the right to authorize in advance, It cannot ratify or make valid anything done in violation of the Constitution. We just showed where it was. First Amendment. Can't make any law respecting the establishment of a religion. Can't do it. Nice try. Too bad, so sad. No motion or measure is in order that conflicts with the Constitution. I'm sorry, page 353, section 517, number 1. Right out of the box here, people. No motion or measure is in order that conflicts with the Constitution.
Unfortunately, no, I don't think that she's out there enough to get any sort of like mental clearance. At the end of the day, what the courts are going to do, like manipulation and everything, regardless of her being manipulated, they will go back to saying she should have notified authorities, blah, blah, blah. She should have walked away when it wasn't working. As far as like Neely is not completely detached from reality. She may be mentally unstable, but the bar is set so high for you to be declared not mentally competent, which that's why you see in the jails we have a lot of people with mental issues in there. And then let me see, let me bring this up real quick. Because, yeah, we already know that the jails are packed full of people that need to be in some sort of mental institution over a prison. But in regards to situations just like this is a case I refer to quite often. Which when was it? Yeah, this was last year. Okay. So basically what happened here, this is a sovereign case, and this actually set precedent for matters like this. This is a case of Heather Ann Tukey Giraffe and Keith Bean, who what they did, let's see, do they give a basic summary? Faced with financial challenges and rising unpaid bills, the individual has two legal options: shed the debts through the humbling act of filing for bankruptcy, or find a new source of assets. Randall Bean, with Heather Tukey Giraffe's assistance, tried to find a new source of assets, an alleged trust fund of government money in his name. But the money was not his, and along the way, the two of them defrauded the United States of $31 million. At the resulting criminal trial, they each asked to represent themselves, a request the court honored after holding a hearing on the matter. The trial did not end well for either of them, as the jury rejected their array of fringe conspiracy theories. On appeal, they argue that the trial court should have forced them to accept counsel in view of their unusual beliefs. Because they knowingly and intelligently made the choice, and because self-lawyering does not require the individual to subscribe to conventional legal strategies or other orthodox behavior, we affirm. So what this is they basically tried sovereign law. Like, this is something that could apply to Neely. This is something that would apply to Arlena Willis. Like, what they're saying here, I mean, this is over sovereign law. There's nothing stopping you from believing this nonsense. But just because you believe this nonsense doesn't mean that they're not going to treat you the exact same. So these guys basically went through court trying to do sovereign shit like Chris was fucking teaching, like Kirk teaches. Then they ended up in prison, and they were like, hey, you guys shouldn't have let us do that. We're trying to appeal this, and now we want a new case because the court should have realized we have no fucking clue what we're talking about. Let's see. It's 11 pages. We won't read all of it. I can also, anybody that's interested in actually reading the full appeal, I just dropped that link in the comments, but let me just try and go down to the moral of the story. Okay. Oh, and that's another thing. The Tukey Giraffe, which I've never known if I'm saying her name correct. I don't really care if I am. She's a former attorney. Yeah, let's just go for the very end. Not quite so. County used Tukey Giraffe while she was experienced as a practicing lawyer. The documents she produced and the arguments she made were devoid of real law. We agree that the arguments were frivolous, but the reality does not get her off the hook. Tukey Giraffe's goal wasn't to fool a veteran attorney, it was to use legal jargon and official-looking documents to disorientate bank and dealership employees, and she succeeded for a while. At trial, one bank employee testified that Tukey Giraffe's identification of herself as Bean's lawyer definitely played a role in the bank's decision not to rescind payment promptly. That sounds a lot like United States versus Crossgrove, where we upheld a special skill enhancement because the lawyer held himself out as an entity's counsel, giving those who dealt with him the mistaken impression that claims would be handled properly. Blah, blah, blah. Sure, Tukey Giraffe's efforts to protect Bean failed in the end, but that doesn't prevent the special skill enhancement, and implying even ultimately unsuccessful conduct can preclude further inquiry. When it comes to crimes like conspiracy, we require only that a defendant intended to employ her special skill and force. Okay, that's not even the part I was looking for. I wonder if this is even the document that I was thinking of. Maybe it's right here. Okay. Tukey Giraffe separately challenges this conclusion on the ground that she should not have been permitted to stand trial or with or without a lawyer, but we tend to treat both claims, this one and the one just addressed, as identical. United States versus Gooch, although trial judges may from time to time impose counsel on mentally compromised defendants just competent enough to stand trial, Indiana versus Edwards, they aren't required to paternalize defendants in this way. That leaves the main challenge both defendants raised to their self-representation, that their idiosyncratic actions and unconventional beliefs establish proof by themselves of unsound mind. But if committing murder does not automatically generate a competency hearing or incompetency finding, we are hard-pressed to understand why fantastic financial crimes would automatically do so. Maggio versus Fulford, Warren versus Lewis. The hard reality is that the libertarian values of the Sixth Amendment allows individuals charged with crimes to act in unorthodox ways, even if that compromises other values of the Sixth Amendment. Just as the First Amendment does not require the individual to accept the most defensible and battle-tested political views, Washington, Virginia State Board of Education versus Barnett. So the Sixth Amendment does not require adherence to orthodox criminal defense strategies. In case after case, we have rejected this argument for comparable reasons. Gooch, Coleman, United States versus Powell. So have our sister circuits, United States versus James, United States versus Neal. For its part, the Supreme Court has never suggested that eccentric worldviews standing alone establish mental incompetence. Cheek versus United States. The hard fact is that intelligent people, even very intelligent people, can believe baffling things. The same brain that allows them to be intelligent can, when combined with financial and other stresses, trigger all kinds of irrational behavior. Count Bean and Tukey Giraffe among that number. Count also the thousands of other straw man conspiracy theory proponents nationwide. These individuals, of course, are misguided, some dangerously so, but that doesn't mean they inhabit a private mental world wholly divorced from reality, and it certainly doesn't shield them from the consequences of their actions. So that's where the problem is with Neely. That's where the problem is with Arlena Willis. This is the problem with sovereign law. It was decided last year that having these crazy ass beliefs and putting them into practice is protected by the Sixth Amendment. The bar is very high when it comes to mental competency. It already is high, but then when you add in like the sovereign beliefs, there's not a lot that Neely can try and fall back on. There's not a lot that Arlena Willis can try and fall back on, because really she needs to be living in a private mental world wholly divorced from reality. If she didn't see reality whatsoever, totally different question there. Um, but this, no. I mean, Neely knows right and wrong. She's got a basic, there's still some attachment to reality there. So the Sixth Amendment protects these people to basically practice stupid shit in court. And that is where the problem lies.
State or the United States Constitution or with treaties of the United States, and if such a motion or measure be adopted, even by unanimous vote, it is null and void. Basically, void ab initio. If it were any more self-evident than it is today's political spectrum as to which side of the political aisle has been engaged in hate politics, you need only refer back to some of the declared conduct of tyrants, clearly spelled out in the Declaration of Independence as follows. He has refused his assent to laws the most wholesome and necessary for public good. Star chambers are inconsistent, repugnant to our republic. Hence, what just transpired as a result of a star chamber clearly falls under this conduct. He has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature. A right inestimable to them, formidable only to tyrants.
And I appreciate that. And yeah, it's 100% money. Like, this is all about money. And that's one thing with sovereigns. Like, you can always 99.999999999% of the time you are going to be able to track it back to some sort of money thing. Like, I just started looking into this, like, I've heard of him before. What's his name? Gonzalez, which we'll be giving him a little bit of spot. Oh, Derek Gonzalez, yeah, that's his fucking name. I got a little bit on him. I just requested for him to come on a live with me and explain some of his bullshit, but he stopped commenting back when I asked that. So yeah, it's money though. Like, and what it is, like, there's a couple, okay, because like sovereigns are hard to like really sum up and group up. And it really doesn't help that they like blend into the Q movement and shit like that pretty well. But normally there's going to be financial issues, bankruptcy, something like that, CPS issues, criminal issues. There's something that like sparks this sovereign belief where they start saying that they basically exist outside of the enforcement of America's laws. And then they also start offering these ridiculous solutions for anything you can imagine. Anything from financial problems to criminal charges to civil cases, they have a remedy for it. But the thing is normally that's where the donations and often love gifts and shit like that, that's where it comes into play, and you need to pay these fees to be able to learn these remedies, to be able to fix your problems. And they end up cramming all this shit in your head, and you go to court and completely ruin your case, and it just goes worse from there. The vast majority of the time. A lot of them will like get rid of a speeding ticket or something minor, and that will be like their proof that they can do anything, and for some reason people believe it. But the problem is, like, sovereigns as a whole do not, there's not just a sovereign group. And the other problem is most of them deny being sovereign, which we've talked about many times. They don't use that term because the federal government deems them to be potential domestic terrorists. In fact, on some of my videos this week, I got people commenting that I'm threatening their lives by calling them sovereign citizens. And also because it's an oxymoron, which the term is. But I didn't make the fucking term. That's what the federal government has deemed it. I have no power over what they used as a term for it. But the other thing, is a good amount of these people don't even understand where the sovereign movement came from, and that it was a fucking racist hate group that was started in Oregon back in the 70s, like 1971, by William P. Gale, and it's basically birthed off a misunderstanding of the 14th Amendment. That's the start of it. It was a group called Posse Comitatus, and it was a racist group. Like, it was for whites. You could not be black and be part of it. They were very much about local government, anything on a county level they recognized, but then anything above a county level they were completely against. And it really wasn't until, like early 2000s and shit like that, that the sovereign groups really started to change and accept everybody in and everything. But William P. Gale and Posse Comitatus, the racist hate group in Oregon in 1971, is what started the sovereign movement. That's where it comes from. DPG, Edward, if I'm full of shit, feel free to prove it, bud. I would love to know where the sovereign movement started from then. I love when they actually have the balls to comment while I'm live. Props to you, though, Eddie, for commenting while I'm live. Most of you turds wait until I'm off.
He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures.
Okay, Edward, could you go into more detail on that? What do you mean by law is law? Because if I'm full of shit, and that's that's a pretty shitty argument for you to say that I'm full of shit, then your reasoning is law is law. Do you have anything with a bit more detail there, Edward? I would love to hear your input.
Remember, we've discussed it on our show. That would be those code commissions that in...
What the fuck are you talking about, Edward? When you add an adjective in front of the word law, it is no more law. God damn it. Oh, fuck. So how many cases have you won, Edward? Yes, I saw it the first time, Edward. When you add an adjective in front of the word law, it is no more law. Gotcha. Law is fact. Okay. Well, you're certainly proving me wrong, Edward. Thank you for clearing that up for everybody. Oh, God, quantum grammar, some fucking Mitch Smith. I should ask Mitch Smith if he'll come on a live. Mitch, if you ever see this live, you should come on a live with me. You're the only one of all these people that I like. I think Mitch is like the only one that actually does not have a bad heart or is trying to fuck people over. I just think Mitch believes a bunch of bullshit. Law with an adjective, it becomes fiction. That's deep, Edward. That explains a lot. What's up, Google account? I'm Deep State. Deep State put a whole bunch of investment into this YouTube channel with 3,000 subscribers. You fucking dipshit. Deep State disinfo agent. Gotcha. Good job, Google account. You get a participation trophy. Well, Edward, after your deep explanation, I see where people are being fooled, because adjectives in front of the law makes it no longer law. So thank you. Google account, we know you by your fruits. Ah. So my fruit is how you have figured out I'm a deep state agent. Cool. Could you contact the deep state and maybe ask them to help promote this channel? Kind of avoid me having to do a bunch of streams, maybe toss a little bit of cash so we can promote this channel and shit. That'd help me out. Fuck, did I just shapeshift on camera? Oh no, they caught me. God damn. So, Google account, what are my fruits though? Google account, the U.S. corporation practices color of law. Google that. Oh boy. What, do you want me to Google this, the whole sentence for you? Oh God, and there's Edward. All the courts are crown commercial courts and not lawful courts. Okay, so Edward or Google account, have either of you used this to win a court case? Discredit the movement by slandering truthers with disinfo. Actually, you know what? You know what? Here, Google account. Explain why this, if this is like a guy telling the truth and he knew the real law, these are the court documents in this video that he's showing that he entered on behalf of Neely Petrie-Blanchard on the charges of her kidnapping back in March. She was indicted on that just a few days before she murdered Chris Hallett. Can you explain to me, if this guy is telling the truth and he knows everything that he's talking about, why was she still indicted after he entered all of these truths? Was that just a deep state true? Or, I mean, what is that? Because it seems more like the guy that is filing nonsensical legal papers on people's behalfs and losing their court cases are most likely the ones spreading disinformation. Ridley, let's not talk about the adrenochrome. You got me, but thank you. Email me. But that is a legitimate question, Google account. Why did Chris lose his case, and why has he lost all of his court filings if he's actually the one telling the truth? But he tells people that he can win. So why is that? How exactly am I the disinfo agent when he's clearly, with court documents and court records behind it, the one making false claims? Innocent until proven guilty. We don't know the details of said case in question. I didn't ask you about the details or if it was innocent or guilty. I asked how come she got indicted, because according to Chris himself, these documents were supposed to put her under protection of E-clause. This was supposed to get her case thrown out, so why was she just indicted last week? Why does Chris Hallett have a very long history of his court documents being dismissed from court when he tells people that he wins cases and that he can protect people? Yeah, use the deep state email. Thank you. I mean, if you prefer, Google account, if you prefer, I can show, like, here, do you want me to bring up one of Chris's losses? Because I got a whole bunch right here. On which I did email Randy Erickson last night. I found an email for her. I started gathering some info on her. And I emailed her, so I'm still waiting for a response from that. Let's see. Which one do we want? I'll just pick one at random. Let me go ahead and make sure it's one that opens. That one does not. I know this is one. I think this is actually the case that he was showing earlier in this video.
Peterson versus.
Oh. You know what? let's just keep that theater mode instead. I believe this is from documents that he was showing earlier in this video. I'm not sure if he's trying to make that falsely look like a win or not. Oh, let's see. Oh, this was his demands. This is where he's demanding like $33 million and shit. Let me see. Redress for dummies. Hallett versus the Department of Revenue, which people have been saying that. I actually have that good chunk of that Hallett versus the Florida Department of Revenue PDF. But I don't know if I want to get into that one yet. Because I'd kind of like to do a separate one sometime in the future of just Hallett's losses in court. Let's see what this one is. This one's a pretty good one. Oddly enough, this decision sounds a lot like what I was talking about earlier, where Chris isn't making any actual point. He's not actually saying what agency did what. He's not pointing out anything in specific. The district court did not err in dismissing Hallett's complaint, for which this is his failed appeal, I believe related to his child support. The district court did not err in dismissing Hallett's complaint for lack of subject matter jurisdiction. Although Hallett alleged that jurisdiction was proper under Bevins, he failed to name any federal official as a defendant. As for 1983, failed to allege that the defendants acted under color of state law and failed to substantiate his claims with anything other than conclusory allegations. Further, Hallett failed to allege diversity jurisdiction properly even after the district court raised the possibility and provided him with an opportunity to amend his complaint. Finally, because Hallett failed to articulate his due process argument with any specificity, I hate that word, and because the district court was performing its duty to ensure that it had jurisdiction over Hallett's complaint, there is no colorable argument that Hallett was denied any variety of due process. So that, I mean, that's like over and over and over again. Chris Hallett lost his cases and told people that he could win this shit. This so-called law you're referencing is color of law. Like, see, and that's the point where I still don't get, because you talk about, you guys, like, that's one of your main like arguments, is that you guys, like, they're disinfo agents or deep state, but these guys are truthers. Like, people like Chris Hallett are truthers, and they're telling the truth. They know real law. Why do they fail in court constantly? Why does it not make sense? Why, after 22 minutes, has Chris Hallett still not named the agency or an officer or anything that he's making these accusations against? We're 22 minutes into this video. He's went through multiple documents. We still don't even know who he's making these accusations towards. In any law, no matter, even in your fictional bullshit laws, how would that work to you guys? We're still not even clear who he's making accusations against. This is what you guys are defending? This is the hill you choose to die on? I mean, I didn't put these together. I didn't put this video together. This is his fuck up of not even knowing how to put together an accusation, but you're telling me I'm the one who doesn't understand any of this. That doesn't work. And then you just go into the fucking bullshit that you guys have been pushed into your fucking brain that you've seen from social media memes, and You think you're so fucking woke. The entire U.S. corporation is for-profit fictional entity. Okay, great. That fictional entity still works under these laws that your law doesn't work with. Like, you go fucking in front of a judge and tell him that under some sort of criminal charge and tell me how that fucking works for your Google account. You'll go to fucking jail. That simple. Fucking morons.
Justice Peterson,
Jesus
the High Court
Christ.
ruled they have no legislative authority. Period. Can't go in and edit the law. Any law. I don't care what it is. That's claiming exercising a power you don't have from a pillar of law that doesn't exist here. This is why these are attacks at law. End of discussion. He has dissolved.
Actually, Jesus Christ, Kev, that's actually a really good question. Like, why are you even citing the United States Constitution? Because why would you want to rely on anything that this government's even made, seeing that you guys recite shit back and claim that it's fucking still under Britain's control and all this other shit? Why would you even reference anything related to the American government if you think it's that wrong? Why even cite the Constitution? Okay, I don't know that we're getting an answer on that one. I mean, that is true, though, Kev. You have a very valid point. Why would you cite the U.S. Constitution? Why not just make up your own laws? The reason people go to jail because they are breaking a contract they agreed to keep and are standing in front of a judge, saying they don't have to keep their contract, which they agreed to keep. It's not about contracts. That is fictional, legal word salad garbage that you guys have tried to pin this sort of shit on. There's no contract. We are under British rule. We stopped going by the Constitution. Let the SC jesters change our Constitution. Okay, so what? We were under our Constitution for a minute, and then we went back? Like, were we... Jesus Christ. All right, I'm going to let this continue to play while we let you guys do your thing.
Representative houses repeatedly for opposing with manly firmness his invasions.
The statute is not a contract. It's Jesus fucking Christ.
On the rights of the people. This is my six-pillar manly firmness foot talking here. So, hence one of my favorite acts from my legislation that we just commenced impeachment on. He has erected a multitude of new offices, sent hither swarms of officers to harass our people and eat out their substance. Well, if that one
Yes, please explain how a statute is a contract.
weren't any more applicable in this case, I cannot think of another place or another case where it is any more applicable than this case. Just saying. For imposing taxes on us without our consent by way of those star chambers, that Title 4D, right? For depriving us in many cases. Why is that a tax? Let me clarify that.
But Jesus Christ. Okay. So you think consent, the word consent is what makes it a contract.
because as I audited Title IV and found out they were stealing 80% of the money in my own case, which I had standing to audit. At that moment, that theft constituted a loss of any status, any standing, or any jurisdiction by that office. Hence the resolution to resolve and dissolve that office. Period. I just think it's ironic that a couple of days ago, as I understand it, in the state of Texas, the child support office was burnt down by the people. Boy, if that isn't any indicator that the people ain't having Sharia law, I don't know what is. I think the people have spoken, right? Another one of those maxims of law from the short list, the voice of the.
Yeah, this is actually documents that he entered into Neely's case that she ended up being indicted on. And then she was at the very beginning of the video. And that's where I kind of skipped through earlier. She comes on again here in about 14 minutes, and then she's on for the end of it. But I'm just letting the whole damn thing play, because what he's doing is he's reading documents that he was entering on her behalf. And like, he already, I don't know if you saw that part, but he claims that she's an agent of E-Clause, and under E-Clause's protection, a little bit back in this video. So like everything you're seeing and he's talking about, this is him fucking up Neely's case, basically. And so that's why I'm just putting this whole video up. I normally would not play this one of their whole videos because it's just boring dribble. Well, I wish I knew what Sharia law had to do with anything that these guys think Sharia law have to do. There's no telling, but apparently Sharia law has something to do with child support officers. I don't fucking know, man. Yeah, the kidnapping was a pretty huge fuck up in her case. That was a pretty huge fuck up. Jesus Christ.
People is the voice of God. Well, when they're burning your buildings down, it's one of the 7 danger signs. You better quit doing what you're doing, right? So, for depriving us, in many cases, the benefits of trial by jury. That's exactly what just happened here. It is what it is.
Yeah.
In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated.
Oh yeah, that's actually pretty spot on there, Adorable. They all, like, somewhere they got fucked over, financially, criminally, or civilly. Some are like divorce hearings and shit like that. Like their buddy John Gentry claimed that he learned his law by watching his wife's attorneys during their divorce proceedings. Chris Hallett fought against his child support forever and kept on losing. So there's always somewhere where they lost their ass to some part of like the legal or financial system, and then all of a sudden they start clinging onto this shit and talking about how that's not how the law actually works, blah blah blah. And you end up with people like Bill and Edward.
Injury. Remember, we have been spurned from the.
Oh yeah, Alicia, I agree with that too. I mean, like, our system's broken as fuck. Our government is broken as fuck. I don't agree with what goes on in our government, but the one thing I do know is going and trying to fight the government with nonsensical legal theories is not going to help. Like, it isn't at all. You can't. I mean, our system's screwed up. Our system's super screwed up. Our government no longer, I believe it no longer has the people in the best interest, and hasn't for a very long time. Still doesn't change the fact that if you go in there just rambling nonsense, it's not going to change or help anything. It's not going to help your case. It's not going to help anything.
Thrown with contempt, right? Remember that from the Sir Patrick Henry's famous speech, "Give me liberty or give me death" speech.
Yeah.
Right? Remember that? I'm just saying, it's a little bit of history there.
Yeah.
So the only requirement for practice in law is knowledge of law and a knowledge of history. I think even bar members are taught Sir Patrick Henry's speech. So,
Right.
just saying. So, prudence speaking from the Declaration again. Prudence indeed will dictate that governments long established should not be changed for light in transient causes, and accordingly all experience hath shewn that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. My favorite line from the Declaration: we now know what the object is and we know what the design is. So I said, this is above Kentucky's pay grade. Period. That crap, shenanigans, kangaroo court, my client and I are not marsupials. I got some news for you. That would be an odious claim. You know, that's this section right here, these kangaroo courts. That's exactly what just went down here. Another kangaroo court, right? So, yeah, not happening.
I can't believe he turned this into a court like that. You don't give the court shit like this. He even put his fucking logo on it. God damn.
This is why, under Florida law, the people again voted for a victim's rights amendment. Well, under Sharia law, Lady Justice is the victim, and the victim has rights. So, because the crime scene in this particular case originally was here in Florida, Lady Justice being the victim, as my client was denied that basic due process, Lady Justice and my client have been the victims ever since.
She wasn't denied due process, like, at all, and she's not being denied due process for the murder of Chris Hallett either.
Have rights. I'm here to assert those rights. So, the above Act of Congress, Title IV, having the effect, remember the cause of the thing causing, which is the cause of the effect. So, Title IV et al. Having the effect of fundamentally altering our form of government.
Ah, there it is, Edward. God's law is unchanging. Who's God? Is that your religion, your God in specific, that the law is unchanging? Because when all else fails, go back to say that you're doing God's law, huh? Jesus Christ.
Government established in 96 forfeited any further right to contract on behalf of and or with its people and businesses as written in Article 4, Section 4 of the Constitution of the United States of America, being properly ratified, citing certain leeways extended in good faith since the Reconstruction Act of 1871. As the courts have long upheld dispensing issues involving fraud and bad faith throughout the history of this nation, I feel...
Anti-God, I'm not mad at you at all. Like, I'm being honest when I say I don't blame you guys at all for not hanging through this one. I just want it on the channel for reference. So I do not... Anybody that doesn't want to sit through the last 20 minutes, I don't fucking blame you. This is why I normally don't play their videos on my streams, because they're boring and uneducated as shit.
Certain this case would not withstand the necessary legal scrutiny.
Well, I could have swore the whole birth of America and coming, I could have swore that had something to do with religion. I almost feel like there was like something like about religious freedom or something like that. I don't know. So it's weird that now it's God's law. Okay, but Edward, what God? So this is what this station is all about. If you don't have God, you have lawlessness. What God, Edward? Because you do know, like, depending on what you are, like, do you think Christianity was the, like, is that the God? Is that God's law?
of a long litigation process under the current circumstances. Statutes, codes, rules, and regulations are not law. See Peterson versus Peterson, appendixed in this document, where that Supreme Court judge actually outlined it for you.
Well, and since we always they always revert back to like the Magna Carta and all this old shit, does it, because I can only assume, Edward, you're talking about Christianity or somewhere along the lines of Christianity. Does it matter to you at all that that is not the oldest religion? Which goes back to my question of what God are you referring to? Okay, just God law is very simple. Gotcha.
It is with a certain sense of pride and satisfaction I got to see the end of these violations of Article 1, Section 9, Clause 8, also known as the Foreign Emoluments Clause, through the efforts of a job that my father did before he died in 2006. This, of course, is Neely's case. He and Christopher Edward Hallett have dedicated a substantial portion of their life to defending known as loss prevention. The fact it is founded on such fundamental legal maxims as fide fiducia, basically in faith and trust, and the malicious designs of men must be thwarted. In closing, I wish to inform you of the following fact. Anyone who has been passing around misinformation as to my death, meaning my client, in all caps, the dog Latin, I regret to inform whomsoever made this claim, I got better. And I'm still known as Neely Petrie-Blanchard, alive and kicking. Sorry to be the bearer of bad news, but we've been had. By who? That would be these useful bar idiots, while we were at work all day long.
God damn it, there's another one. Useful bar idiots, snake oil salesmen. You've been scammed. That's very ironic that he passed that there. Benefit, bar, profit, gain, advantage, market. God damn it, it all makes sense.
So their version of reconstruction, or I'm sorry, yeah, their version of infrastructure projects and our version of infrastructure projects, no. So that would be that monopoly leveraging. We were just, matter of fact, Attorney General Barr just spoke about that over social media, over a social media executive order the president just signed, basically ordering that activity is repugnant to the law. Also clarified in my judicial report. Let's see here. That was researched by this office. Here we go. Legal monopoly. This is all from page 1160 of Black's Law Dictionary, 10th edition. Legal monopoly from the 18th century. Monopolies from the 16th century.
Hey, Edward. Romans 13:1-2 says, "Obey the government, for God is the one who has put it there. There is no government anywhere that God has not placed in power. So those who refuse to obey the law of the land are refusing to obey God, and punishment will follow." Again, that's Romans 13:1-2. I would love to hear your response of it saying that those who refuse to obey the law of the land are refusing to obey God, and punishment will follow.
Century, right? That branding, right? We've discussed that. My client has been branded. I thought we quit doing that in the late 16th century. So we now have these bilateral monopolies, these foreign emoluments, creating these bilateral foreign monopolies, hence the Foreign Emoluments Clause. Exercising this monopoly leveraging.
You can give me more verses, but you're going to ignore that verse? Is that what you're saying? Oh yeah, if there's confusion, that's why I got links up there. And like honestly, I like my Facebook peeps and everything, but the YouTube channel's been way more lit as far as comments go and shit. So there's links in the description where you can bounce back and forth to the YouTube channel or the Facebook page. But yeah, most of the responses you hear is YouTube, because YouTube comments have just been way fucking more entertaining. Submit yourselves to every ordinance of the man for the Lord's sake, whether it be to the king as supreme. Edward, I think the verse you just used to prove your point actually goes against your point. That says to submit yourself to every ordinance of man. God damn it. Oh, good job, Edward. Good job.
Right? Monopoly, through their monopoly powers they don't have. Period. We've discussed this, such as unauthorized practice of law. That's laying claim and exercising a power you don't have. Period. That's been tested and defeated so many times.
You're doing a good job of trying to get people to see, Edward. You're doing a great job.
In multiple federal courts. Don't even try it. Talk about repugnant. So, there it is. Congress shall make no law respecting an establishment of religion. The First Amendment. It's the reason that this office was created. I knew what you were up to while I was at work all day long. So, we're going to talk about the common law. That would be God's law, hence the citation of the Lord's Prayer. So, and of course, there it is. The voice of the people is the voice of God. Hence, proper service of process. It's already happened. The fact that they don't want to accept that they're caught and they're done, well, that is that's unfortunate for them. So in so much as the notice of appearance is concerned, right? This is in Congress. You were served it. Here's your notice of appearance. Christopher E. Hallett, doing business as E-Clause LLC, is hereby filing this notice of appearance to my status change, fiduciary expert, friend of the court, per the following circumstances and establishment of practice, to retask my fiduciary license to serve the people of the United States of America as loss prevention co-counsel for the government of the United States of America and plaintiff in this matter. On March 13, 2000.
Now that is what, in January, a federal judge said he was not going to entertain that fantasy that Chris Hallett was acting on behest of the president. 100% federal judge threw it out, said, I'm not even fucking around with you. This is not real.
2017, POTUS, President of the United States, issued a lawful executive order, 13781, in which President Trump asked for help from the citizenry. That would be those with those lawfully created emoluments. I know that. I got one hanging on my wall. To assist in the restructuring of the executive branch. Again, a task not undertaken lightly. Citing the...
And yes, the court does have to read this stuff. That leads back to what we've talked to before with paper terrorism and why you're seeing that become a thing across the country, because they flood the courts with these nonsensical documents. And places are getting sick of it, because regardless of how ridiculous this is, somebody still has to go through it, and it's still wasting the court's time. So that's where you start getting into the paper terrorism and shit. And then like situations with like Arlena, where the judge has said, like, you're not allowed to file shit anymore. Everything you're filing is fucking nonsense. One of the last things she filed was for a case that was already closed. Like, she has no clue what she's doing, and she's just filing shit, but somebody still has to deal with the shit that she's filing. That's where you're starting to get into legal problems from following this and just flooding the courts. And right now, that's still a developing thing over the last few years as the sovereign legal theories start to gain more popularity. So across the countries, it's like different punishments and fines and whatnot as you as it's being developed, basically.
Key tam provision. There it is. I am following said executive order. in a continued effort to expose these continued assaults upon the court by frauds upon the court through malfeasance of office and prosecutorial misconducts, resulting in multiple emoluments violations through Sharia law. This office does business hunting for the following red flags in both public and private sector corporations. That is a public sector corporation. Audit forthcoming. Pursuant to Article 1, Section 9, Clause 8, the Foreign Emoluments Clause. So, what is an emolument? In order to, basically, under this legal maxim, in order to rightly comprehend a thing, it is necessary first to inquire into the names. For a right knowledge of things depends on their names. So the definition, as recognized in a republic, 3 pillars here. Advantage, profit, and gain. Any advantage, profit, or gain received as a result of one's employment or holding of office. That would be those stipends that Bill Barr talked about during his confirmation process.
It wouldn't. No.
We already know about falsehood. The law punishes falsehood. This is the reason everything that's transpired is literally a defamation, libel. Further pursuance of this action against my client, any in this office, is libelous. Know it, understand it. Under my fiduciary licensing, my reciprocity agreement with the people, as I clearly outlined, there's its definition as a corporate officer. I know my job. Been doing it for 30 years. I'm really good at it. So, again.
No, actually, Alexis, you're like the third person to say that tonight. So I think we've come to a group conclusion that it is not too soon to make not being bulletproof jokes against E-Clause.
What is unsuitable or...
Remember, there's no sympathy over on this channel for them not happening. Don't think that it should have. I mean, it's not something to celebrate, but there's no sympathy over here. And the internet is what it is, so... Don't know what to tell them.
Contrary to reason is not allowed in law. I think we just cited that into this context of the Masons Manual, didn't we? So, notice of appearance.
See, and that's a very good way to put it, Adorable. It's half-truths. And, like, that's like always with these conspiracies and sovereigns and shit like that. They use one piece of truth. Like Jeffrey Epstein has been a latched on thing for this fucking whole pedophile fucking save the children thing, even though like it wasn't anything new. Those people knew about Epstein since like 2007, early 2000s. That was known. And like even with Epstein gone, that didn't even take out a 0.5% of the trafficking in the world. So, but it's great though, because they can use that and say, well, it's all of this because of that. And there's that one real part. So, I mean, yeah, it's half-truths. That's what they rely on, is half-truths to try and get people to believe this shit.
Appearance covered. So what are we going to disclose today? Well, remember, full disclosure is a requirement under lawful agency practice, right? We've discussed this. Discovery in the criminal or civil process as seen by Lady Justice. Full disclosure in the private sector. Those things are equal, right? Lady Justice has the right to discover, right of discovery here, since she is the victim, as is my client. Again, received. Period. Somebody want to explain to me and my client why the court was denied this exculpatory evidence reciprocity agreement between the quote-unquote plaintiff in Kentucky and my client. Somebody want to clarify that for me, because this is going to be brought before oversight. So under the required records doctrine, be prepared.
Which that's her mom at the top of this.
To bring your case and all of your files to oversight, because you're going to answer for this, right? It is what it is. And there it is, signed and notarized, right? There is another document, an authorization It looks a lot like an authorization to me since it's titled as such, and it is signed by your plaintiff up there. So this would be exculpatory on behalf of my client, I would certainly imagine. So denial of this evidence being brought into today's process is an emoluments violation under Brady. And I'm going to petition for a contempt sanction against any actors who are so involved in in this process. Period. You're done. You're going to remove you from office. You're going to be impeached. I'm sure you know what impeachment is.
That never happened.
And of course, we'll go into where everybody was served. Through email were served. Let's see, Office of Attorney General memorandum. This is from General Barr, I think, put this out, isn't it?
Yeah, it is. Okay. It was served on them a while back ago.
Right.
And they act like they can't find it. Yeah.
So again, this came from the Attorney General of the United States. You were served. You now have been served notice of process, not just by this office, but you were served also on November 16th of 2017 by wait a minute, that could be Jeff Sessions. I think this is Jeff Sessions.
Yeah.
But this also holds prohibition on improper guidance documents. These Title IV Sharia law courts? No. That was shut down in November of 2017. What are you doing? So we're going to motion to suspend the rules of Title IV, right?
Jesus Christ.
This, again, I just showed this. This was also served by my client. Proper service process. This office has jurisdiction.
Yeah, fraudulent statements notarized and filed in court is punishable by law. You are correct, Will.
Right? The defendant by plea or exception becomes plaintiff.
Yep, Fields' little one man from Trump was David Straight. That scumbag.
Some of law right here. What's the plea or exception? Emoluments violations under Brady. Period. Know it, accept it, understand it. Justice and fraud are basically incompatible. That's pretty much what that one says. I'll go down the short list if anybody wishes me to. So, without going through the entire petition again.
That he lost.
This is pretty much exactly what just happened.
And lost the appeal too.
So, this is going to conclude today's official meeting, unless, of course, my client wishes to provide a statement. Now, knowing and understanding that her First Amendment right was just violated because they attempted to gag her.
Yeah.
No, that would violate your free speech.
Yeah, I'm going to go ahead and go with Hannah's or Foxgrin's hashtag on that one.
Right.
So, again, right. As far as I'm concerned, as far as your corporate counsel is concerned, I'm telling you that violated your First Amendment right. So, right. And I'm providing notice of process as to that violation and where and why it's above their pay grade.
Right.
I've already handled this case.
Right. Well, they know they're depriving my liberty interests. They just, Well,
and again, it's Islam. Welcome to Islamic Nation.
Right.
Well, in so much as the modeling is concerned, you go through the model that just happened. Right? You guys have seen this. You guys have seen this model.
Oh, no.
Right.
No.
In proper agency practice.
No.
No,
not another colorful picture. Governments cannot create markets outside the scope of the Constitution. Quid pro quo for what? Government monopoly, markets with little to no reciprocity, all managed by foreign emoluments, working with pillars of law, violating state constitution is the guide we use in commerce. Dude, this is nonsense. Oh my God, it's just nonsense. Why is "why" in quotations at the bottom? Like this, right? Why is that?
Quid pro quo, the what for what, and the reciprocity, that would be an equal return, right?
Why?
Reciprocity agreement.
Why?
Well, these government monopoly markets with little to no reciprocity, all managed by
There's only 8 minutes left, though.
foreign emoluments, bar members, working from pillars of law, violating violating Article 1, Section 9, Clause 8 of the Constitution's Foreign Emoluments Clause. Period. This is why the courts, the high courts, correctly ruled as they did, invalidating Title IV et al. And Obamacare, basically et al., in context mandating full repeal. Hence the reason the Foreign Agent Registration Act was just expired.
God,
Happy trails.
God damn it.
Don't let that Admiralty jurisdiction anchor hit you in the ass on the way out the door.
It's not
right?
It's not.
So,
And star chambers are unlawful.
oh yeah, those are definitely the ultimate in repugnance. Again, what I cannot do in my person, I cannot do through the agency of another, which is why this office is holding a public disclosure. See the difference here?
Yeah.
Between what they're doing and what we're
Yeah.
doing?
Yeah.
So, again, if
No, I mean anybody can file anything in a court. I mean anyone can. Like I like fake reality. I can sue your YouTube channel without even knowing your real identity. It doesn't mean it'll go anywhere. And if I can't ever figure out your real identity, it's definitely not going anywhere. But yeah, like I can just go file some bullshit against your YouTube account. It means nothing.
I'm going to train you, I'm going to train you correctly.
Right.
Not incorrectly as they have been trained.
Right.
So, because these things have already happened, right? It is what it is. And so, in so much as discovery, okay, well,
that's pretty good. I know that when I'm writing a legal document, I too choose Comic Sans. Oh my God. It's so painful. It's so fucking painful.
let's talk about the Hobbs Act. There it is again. And let's go. So as far as the
Oh, really? Kirk just went live?
slideshow, inevitable discovery. Yeah, what is inevitable discovery? This is an exception even in criminal law, right? Even if there was any kind of misconduct, as these are in plain view, there's the emoluments of my office. What does that mean?
Welcome.
That means I am amenable to the people. It is what it is. So as a lawfully created emolument, amenable to the people, I'm doing that job. I don't care who likes it.
It's a notary.
President asked for my help,
No,
and I'm going to tell you right now,
no, he didn't. The president did not ask for his help.
going back to the Minutemen, Annals of America, Volume 2.
Yes, that is my ex. She's the one who yesterday we found out, or the night before, that with that Francesca Amato, there's some screenshot, and she was the other part of the screenshot. Fucking where they were saying that I hypnotized and drugged Neely, and fucking yeah, I don't even know. But that Francesca Amato, another sovereign scammer, like has been posting that in this E-Clause group, and it was a screenshot of a message where it was saying that. It turned out the person from the message screenshot was my ex-page. So
Look it up, verify it, know it, live it, breathe it, understand it.
Read
President issues a lawful executive order asking for your help. I'm duty bound, fiduciary duty bound to respond to that.
And we have a duty,
Well,
period.
again,
You know?
I know the law. I've forgotten more about the law in the Republic than these people will ever know.
That's
It's kind of
not
the
true.
nature
He doesn't
of
know
practicing
the
the
law.
Republic for 30 years,
Right.
in so much as due course is concerned. So remember, we've talked about this. Your dad's position and my position in our companies as corporate officers was literally the corporate parliamentarian. We're the backbone of the company, right? He'd get a phone call. He had to quit whatever he was doing to respond.
Yep.
It is what it is. It's the nature of the job.
Yep.
This
I
is
know.
no different. This is no different.
I know.
So on that, I'm going to go ahead and end this live stream right now. So
What was the point of
anybody
Neely?
who is paying attention to this, who is in official office of emolument with reference violating my client's rights, or if you think you're going to intend to violate me, I'm going to hold you in contempt, and I have power to do that. So in so much as one last final thought here,
What was the point of even having Neely on? I don't think she even got to talk for 2 solid minutes.
one of the reasons why this this particular case was removed by this office. Remember, I did an audit of this case, and what did I find? Right,
Thank you, Sydney, but it's all right. It's for the best.
I decoded this case. We talked about this one night on the show, and because this right here, Kentucky, this is what they're currently trying to pull, 4243, right?
Yeah.
From 2014. Wait a minute. What year is this? Okay. Yeah. There was never a hearing on this, right?
No, there was never a hearing.
You never were.
Went to court.
Okay. So you were denied due process.
Yes.
So how were they proceeding under something that you were summarily denied basic Magna Carta due process?
Right.
So in the decoding, remember, I clarified this. I have found just in that system, okay, there are 2 files, and both files do not contain the same information. That is the selective inclusion of and selective exclusion of relevant evidence and testimony, which prejudiced the court against my client. Emoluments violations under Brady. Period. Dating back to 2014.
Well, and it's okay that she doesn't say much, because still at the end of the day, the main reason we wanted is to show the crazy shit Chris was pumping into her head.
They never had any status. They never had any standing, and they never had any jurisdiction, notwithstanding foreign emoluments notwithstanding, right? But any jurisdiction they may have had. When they created these...
Man, I have Kirk's ready to pull up, but there's like a minute and a half left. I don't know that I'll stay on Kirk's very long at all. Not happening. Like, I don't think I can do Chris and then Kirk solid.
shenanigans, right? This is a file and a sub file, right? They say, oh no, it's
We are 1 minute and 30 seconds away from checking out what Kirk is saying.
in the system. Yeah, it's in the system, but as you can see, the file numbers are different. So if you're going to search for something in either one of these, if you don't put the 3 zeros in, you're not going to get the whole picture. Right? That would be that information in due process that's required, that Brady information, right? That fundamentally alters the proceeding. Well, it is what it is. So there is your visual citation of emoluments violations under Brady with respect to this case dating back to 2014. Attempted to provide this information this morning and was threatened for that service.
I'm more interested
again,
to jump to Kirk.
I don't respond
though.
well to threats under domestic terrorism. We have law against that. That's domestic violence under Article 4, Section 4. So know it, understand it, deal with it. This office does have limited judicial power under that jurisdiction. I removed this case because of those violations in the audit conducted by me.
Okay. Come on.
right?
I was threatened to
Good job, Neely.
So
again.
anyway, on that note, for everybody who is getting ready to...
Okay, that's good enough. Yeah, Kirk blocks. Kirk will block you real quick.
Bill of Rights Day, we recognize the importance of the first 10 amendments to our Constitution, to protecting our liberty and freedom against the inevitable encroachment of government. Our founding fathers understood the threat of expansive, omnipresent government. From the beginning of our republic, see, that says republic, not democracy. Okay? Therefore, they endeavored to enhance the Constitution with a Bill of Rights, a specific enumeration of fundamental rights, key word, fundamental rights, that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. Okay? On June 8, 1789, James Madison, originally skeptical of the need for a Bill of Rights, introduced in Congress several amendments to the Constitution, and they were not actually amendments. They were articles. And I'll show you where it was printed as articles. But anyhow, that would eventually form the Bill of Rights. During the ensuing debates, Madison told the Congress that because all power is subject to abuse,
God, dude, he
it was
really
worth
did
taking
not
steps
even
to ensure
skip
that
a
such
fucking
abuse may be
beat.
guarded against in more secure manner. Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans. The right to worship as we please. That's a right. The right to speak our minds and consciences. Right. You do have that right, but remember, you have to be responsible when you speak your mind, especially when you're talking about somebody else. Your rights stop where somebody else's rights begin. And that's why we have the law on libel and slander. Okay? Thou shalt not bear false witness. It's the 9th commandment.
What the fuck is he
The right
going
to
on about?
firearms to protect ourselves and our loved
Oh yeah, Kirk has said before, like I think he thinks libel and slander are criminal charges.
ones. Well, that's a right. The right to be free from unwarranted government searches and seizures. Yes, we have that right to
Let's
be...
back it up. I'm interested how he even started this.
There we go.
God, he looks like shit.
Oh, Lordy. I have to do all this all by myself, see? All right, so I've got, let's see, let's start over here. Back to the beginning. Back to the beginning of when all this...
Oh no. No. I'm sorry guys, I can't. Debunking sovereign citizen and going over Trump's no, I can't after listening. Maybe later tonight or tomorrow we'll watch this and go over it, especially if he's debunking the sovereign citizen. I can't go straight from Chris to this. Like I can't do it. I won't do it. You guys cannot make me do it. You guys will not make me do it. I'm not doing it. I'm not fucking doing it. No, ain't happening. Not right now. I can't do it. I can't do it. I'm tempted just because of the sovereign citizen part, but nah, that's not happening at all. It just isn't. I do want to hear his debunking of sovereign citizen, though. That sounds pretty amazing. No, no, Kathy. No, no, no. No, no, no. No, 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 no. No, it's not happening, Kathy. Not happening. Dude, that was bad. I don't even know if I've ever watched one of their videos all the way through. That no, Chris was enough. Hearing the bullshit he was pumping in her head, that was enough for the night for me. Or at least for a few hours. Like I can't do it. I can't fucking do it. No, so that and again, we just wanted that just to show the shit that was being pumped into her head. Chris fucking telling her she's protected by E-clause, all this other shit. It's not. I mean, it's clear what happened here. These guys led a mentally unstable woman on with some very serious shit, and I mean this is what happened. Like that was complete legal nonsense that Chris spit out in that video and was feeding to Neely. That was beyond legal nonsense. I don't know. I think that helps to see a little bit more clear. Having all that shit, she thinks that her attorney, whatever the fuck you want to call it, Chris, because he kept on calling her client and his officer, she thinks he has been appointed by the president and that all of those like fucked off diagrams and stuff is real and he's got protection for her. Yeah, I think it's pretty clear how this woman got pushed over the edge. Catherine, I think I've seen that too, that Kirk has been deleting videos and posts. I'm pretty sure that is true. I mean, all of them do that. Like, Field's shit had to go all the way down. And I think they used to do shit like that beforehand. That's why we're appreciative of channels like Glow 5 and shit that, like, Glow is who, I have that link in the description if for whatever reason you want to sit through this whole damn video again. Yeah, Glow has been doing a good job of taking these guys' shit and putting it up somewhere else so it's not lost for good. And that's basically what's going on here too. If she gets hit with any kind of copy, or Glow, I forget if you're boy or girl, and it doesn't matter, because none of you need to know who Glow is. If like Glow gets hit with a copyright, that's another reason why I put it on these channels, because we're doing a discussion over it and shit like that. We have a little bit more room to play with as far as right now we do have some common use protections and shit like that, because it is an important part of a discussion that we're having here, and we actually break the videos down. That's another reason why I stopped the videos and we talk about parts of them, because we're not just trying to replay their shit and rip them off. We're actually sitting down and talking about what points they're trying to make in the video. So I think that'll do it though. Up in the description we have that link to Glow's upload of this. There's also a link to the article I did on Neely during the kidnapping. Fuck. Okay, my bad. I totally forgot. I set up an email for you guys to email stuff to me. I did not include that in the description. I will put that in the description for the next videos, though. I'll remember that. There's also descriptions to support the channel. Anybody that supports the channel, you guys are awesome. Obviously, this is not the funnest thing to do ever at all. So your support, subscribing, following, donations and shit like that, all of that's appreciated. And I think that's it. I'll skip through what Kirk says tonight, and we'll see about playing that one. And if not, then Yeah, I don't even know. I'll at some point I'll check out what Kirk says about debunking sovereigns, because that does have my interest. I'm not making any promises on that though, because again, I hate both of I hate their videos. I hate them so much. They are so boring. They're full of so much garbage. I just hate their videos. So we'll see. If he like super goes into sovereign debunking, then we'll go ahead and show where he's wrong. But God, I almost hope he doesn't. But you guys have a good night, and I will be seeing you guys again soon.